presentation on the role of a planning commission and planning and zoning commission. We have a combination of the two here in town. They're not always that way. Sometimes you have a planning commission and a zoning commission. Mr. Royston's going to inform us. And for us, some of it will be review. For others, it will be brand new and fresh. At the end of this presentation, there will be an opportunity to ask questions on the material that's been provided, and if you haven't, you have it in front of you, so you probably have already seen it, it's also emailed to you. So whatever specific questions you might have, I think Mr. Royston will try to answer whatever question might come up. And with no further delay, Mr. Royston, welcome, Happy New Year, and the floor is yours.
Thank you very much, Mr. Chairman. I'm on the clock, and this is an excellent setting because I got it right here. I promise to conclude between the 9 and the 12, so that gives me half an hour to 45 minutes, and I'll stick to that. First of all, I believe you got two sets of documents. One is entitled Zoning Authority. The other one is entitled Planning Commission. They were sent at different times. These documents come from presentation materials that the Planning and Zoning section of the Connecticut Bar Association puts on for land use attorneys, and there's another session which usually is in the spring of each year at Wesleyan, which is for land use board members. And I know Tom has attended that seminar. It's for officials and members. And he can comment on the value of it. I think it's a very, very helpful seminar. You get the big book. These are basically excerpts from what I was a presenter concerning zoning commissions, the zoning power. And so I fortunately had my material, and I edited it, cut it down, took out most of the statutory citations, most of the case citations. You'll see in there where certain material are in quotes, and that means the language came verbatim from either a case or a statute. For the Planning Commission part of it, I plagiarized from my colleague and good friend Timothy D. Bates, who is a land use attorney in London. He was likewise a presenter. I got his material kind of omni-troed it so I could put it into a document that I could edit. I edited it to again remove most of the statutory citations, most case citations, also material which related to where you have separate planning and zoning commissions. For example, Old Saybrook, the commissions are separate. Essex, the commissions are separate. Chester and Deep River, they're combined, and I either represent or appear before all of them. Westbrook, separate. So 3 and 3, and that's pretty much consistent with the state. It's about 50-50, whether they're combined or separate. So let me get right into the zoning part. I'm going to do that first. And again, I'm going to try to just hit the highlights, and then certainly I'd be happy to answer questions to the extent I'm able to. Starting out under the zoning authority outline, the first part is history and legislative authority. Basically, Connecticut zoning starts essentially 1924. Before then, there was virtually no zoning in the state of Connecticut. So even though that's a considerable period, you think about, well, 90 years, you still have uses you still have factories, buildings, construction, which predates zoning, even from the very beginning. Zoning in Clinton, 1965, so now we're during a much closer period of time. So just think about that. Zoning is a legislative authority. The state of Connecticut, by statute, says that a local community can adopt zoning. And under section 8-2 of the statute, it says basically how you do it. And so if you would be wise at some point, get a copy of section 8-2, because that's the basic statutory authority for everything you do. It says exactly what your powers are. You don't have any powers other than are delegated to you as commission members, A, by the state of Connecticut saying that your town can adopt a zoning ordinance, and B, the fact that this town of Clinton has adopted a zoning ordinance. And the ordinance is not your regulations. The ordinance is that which establishes, or originally established, how the commission was to be formed, who would be members, how they'd be elected, appointed, or what have you. And once the commission was established, boom, you then have the authority to adopt regulations. Regulations is under 8-2. 8-2 tells you what you can do. Divide the town into districts. Within each district, specify uniformly what the uses are within that district. You also have to provide for a mechanism of enforcement. You have a zoning enforcement officer in Clinton. The statute just says you have to provide for a mechanism for enforcement of the regulations. Statute says you also have a ZBA to do two things, two essential things. One, if somebody's got a gripe on an interpretation by the zoning enforcement officer, then they can go to the ZBA. If someone seeks a variance to do something not allowed by your regulations, then they go to the ZBA. And the statute says if they're going to get a variance, they have to demonstrate a hardship applicable just to their land, and that whatever relief they're asking for is consistent with the comprehensive plan of zoning. Okay. One thing you'll notice if you go through this stuff, I underline the fact, comprehensive plan of zoning and your plan of conservation and development are two entirely different things. I don't know why they kind of cross this stuff up in the statute and use this idea of a comprehensive plan as opposed to a plan of conservation and development. A plan of conservation and development, which you do under your planning function. Every 10 years, at least every 10 years, you develop a plan of conservation and development. That's kind of a general outline, a guideline of how you want the town's future to progress. And in your plan of conservation and development, you're kind of saying, okay, we want more industry, we want more housing, we want affordable housing, we want to take care of septic problems. You have a whole variety of things in your plan of conservation and development. And only some of those things are within your jurisdiction as zoning power to put into your zoning regulations. And what you put into your regulations is supposed to have a consistent sort of framework. And by that, it's really means, well, in your regulations, if you have an industrial zone, a commercial zone, residential zone, will pretty much allow industrial uses in your industrial zones, commercial in your commercial zones, residential, or those that are homogeneous to residential zone, and protect health, safety, welfare, property values, avoid congestion in the streets and that. Okay. Comprehensive plan is what you put into your regulations. Okay. Plan of conservation and development is a general guideline which you prepare for the town. When I say the town, Board of Selectmen, other agencies, Water Pollution Control Authority, that's sort of a document which they're supposed to be looking at. And for yourselves, when you get to do your zoning regulations. There are situations where zoning commission authority is limited. You do your regulations, and like everything else, you're going to find there's every blanket statement, there's going to be an exception, and there's going to be plenty of exceptions to it. And I just briefly went into the area where there are limitations on zoning authority, certain religious land use, telecommunications. You don't have authority over whether or not somebody can put in a telecommunications. That's under federal law. The Siting Council has specific authority over that. Signs and political signs. You're dealing with free speech elements regarding the ability of someone to put up a sign in their yard. So there are different things, of course, where there are limitations upon the zoning authority. You have a bunch of other statutes, which I won't get into, which deal with affordable housing, deal with community residence for mentally retarded, things of that nature. There's certain statute which says by regulation you cannot prohibit certain types of uses. How you adopt regulations, and I'll just go really quick on that. Adoption of regulations is basically the process which you have to do. I know you have a regulations subcommittee. They work on coming up with regulations. If regulations are commission generated, you still have to have a public hearing before you adopt them. The public has the right to comment on what proposals you may make, but you are not under the same time clock as you would be if I, as an applicant, comes in, as a private citizen comes in and says, I want to make a regulation change. You'll have to have a public hearing, but you're under time constraints with respect to how you handle that application for the public hearing and how soon you're going to decide.
Is that the 65 days? Is that?
That's your basically 65 days to commence the public hearing, 35 days to complete the public hearing, 65 days to make your decision, with another 65 days which can be used for any part of that for extensions. Okay, those are
65, 35, 65?
65, 35, 65. And then you have, for extensions, you have additional 65 days, which now can be allocated over any portion of that of that time period. That's been changing, but that's what it basically is now. When you are adopting regulations, this is, I think, critical to everything you do. You're acting in a legislative capacity. You are lawmakers. You are writing laws. You're like Congress. You're like the Connecticut General Legislature. You're writing laws. And pretty much the same standards apply to your regulations that you write, which do other laws. The Congress, of course, has to write laws which comply with the United States Constitution. You have to write zoning laws which not only comply with the United States Constitution, but the Constitution of the state of Connecticut, and also 8-2 for the statutory authority under which you write regulations. But as you go through here, when you act in a legislative capacity, you have very broad discretion. And unless what you're writing as regulations is beyond the scope of Section 8-2, then you should be okay. You are, the courts pretty consistently say, you're the best judge of the needs of your community, how far the district lines go, what uses are going to be allowed within those districts, what density of uses within each district, what limitations, things of that. You're the best judge. And as long as you are doing what 8-2 says you can do, you're going to be okay. Read 8-2, because you'll say, it keeps on going on, and then it throws something in which you shall do, and then it throws something else in which you may do, and something else which you need to consider when you do regulations. It's because 8-2, instead of having separate sections that just keep on adding to it, just keeps on getting added to. So as you read it, it doesn't make any logical sense or progression, but it really is a guideline for what you're going to be able to do. In making regulation, I'll do that pretty briefly, because as your chairman has indicated, when you do regulation, you have to have public hearing, you have to have notices, notice in the newspaper, and there's certain filing requirements, and those things that your staff is well-trained to do. And it's critical. It's critical. There have been appeals taken for Clinton, and one of the bases of the appeal is that the map reference to a zone change, which was filed in the town clerk's office as required, was not sufficiently accurate because it made reference to the assessor's map, and was that a lot assessor's map number which itself was not filed. So the commission was successful in that appeal, but that's the sort of thing you're up against. Reasons for your decision, to state them on the record, even on legislative actions, rulemaking under your regulations. If you adopt regulations, simply state the reason for them on the record. In your regulations, zoning has changed. I have copies of the Clinton zoning regulations back in 1965 when they were originally adopted. Okay, There may be 20 pages. Same thing on all the towns. Zoning originally, pretty much, for up until the 70s or 70s, 80s, zoning pretty much was just put the town in districts and say what uses can be done in those districts and set up the mechanism for enforcement. That's it. Special exceptions or special permits, nowhere until more recently. Site plan review to determine whether or not a specific proposal meets your regulations. That's a fairly new development in land use law, relatively new. And it is critical to understand that when you're dealing with special exceptions, someone comes in, it requires a public hearing, or you're dealing with site plan, doesn't require a public hearing, but the applicant brings in a plan, the commission considers it. Those instances, you are acting as administrators, you're acting administratively. You're not making laws. You can't say, this is a bad idea, so I'm not going to put it in my regulations. That's a legislative decision. You have to take a look at whether or not the application meets the standards of your regulations. And when we get into the planning and zoning, the planning section, same thing on subdivisions. The question is whether or not it meets the regulations you have adopted. Not whether, gee, that subdivision is really kind of dense for that land area, or it might better be, those houses, their housing locations might better be otherwise. You have far more limited discretion. Once you made your regulations, that's what you should be looking at. If an application meets the regulations, it should be approved. If an application does not meet the regulations, it should be denied. There is, in between, the ability for you to attach conditions. And that's probably the only way that you can make something that does not meet the regulations, in your view, comply, is by use of conditions. Special exceptions have some very, very subjective aspects to them, where, and there is law on special exceptions, which says that these are uses which are allowed in the zone, permitted in the zone, but only where you have determined, made a finding that the use is appropriate for the place where it's being proposed. The critical case is Whispering Woods, I believe the name of it, where a gravel pit was proposed, which was an allowable use in a residential zone by special exception under the regulations. It had to have so many acres of land. The operation had to be so far away from abutting properties, etc. But the regulations were probably deficient, but that's what the regulation says. Unfortunately, in the application that came in, the applicant was able to meet all those requirements, but the only way you got to the property was through a very circuitous route through a residential neighborhood. We had a lot of families, houses, kids, and the commission determined, they said, you know, that's not the right place. You can't get in and out of there without a problem. And they denied the application, went up to court. The court upheld it, because the location was not deemed suitable. But you got to be very, very careful on that sort of a situation. It is when you're acting on particularly on a site plan. Site plan, there should be far less discretion. You should not be, and you go through your schedule, the SPs and the SEs, and if you go through though, the whole basis under your regulations for all these use categories is that as of right, you shouldn't have to ask anybody. If you're going to build a house, single-family house in a residential zone, you don't have to come to the commission. Come in with a plan, with the zoning enforcement officer, takes a look at the plan. If it complies with setback and the like, and you have a health permit, you should be able to build your house in a residential zone without having come to a hearing. There's other uses, commercial, they're saying, look, the use is what we set up our commercial zone for. There isn't any question, and for this particular use, in any commercial zone, you shouldn't have to have a public hearing there because there isn't that much discretion. Question is, does it comply? Special exception is one step above that. Special exception, you do have this sort of limited area of discretion. Is it appropriate for the district? And keep in mind those qualifications. Evidence, what you can receive as evidence in a public hearing. As your chairman said, you have rules for the conduct of a public hearing. Having seen how your public hearings are conducted, I think you are well within the parameters required by the court that public hearings be conducted fairly so that the parties and opponents are given the opportunity to know what's being presented, to ask questions about it, and under circumstances, if they're requested, to be allowed to cross-examine expert testimony or witnesses. You can conduct that through the chair. You can keep tight control over the conduct of a public hearing, and you should. They should not become free-for-alls or what have you, but you need to conduct them under principles of fundamental fairness. What's fundamental fairness mean? It's just like, I forget the Supreme Court Justice on pornography, I don't know, but I know it when I see it. It's the same thing under fundamental principles of fairness. You know, your gut is really going to tell you whether or not it's fair. From my observation, hearings have been conducted under principles of fundamental fairness. Where problems come in, as noted particularly by Commissioner Rossi, is in today's age with Facebook and email and Twitter and what have you, the amount of comment that is out there that you are subject to, people calling you what have you, is enlarged. You know, it's much more. What you said is exactly right. You should not receive comment or accept at a public hearing when a matter is pending, or public hearing is closed and the matter is still under decision. If anybody wants to talk to you about it, say, could you put it in writing or come to the meeting and make that comment? You know, I think you can say your point of view is valuable, okay? But the commission needs to get it, not me. Same thing on any other communication. I think if you refer it to, you know, the chairman from papers and the like, that's absolutely appropriate. And I think you need to rely upon your chairman to exercise the judgment necessary in that case. In other words, you do not prejudice any party to the application. And if you find that he fails in that duty, you're reelected as another chairman. But again, I think it's a judgment that is best to refer it to one person, because there is then no question, well, the commissioner said, and this one said, and the chairman said. Now, there's one voice on that. Public hearings, you can do not discuss them between yourselves. And again, discussion is communication. Communication now is widespread. Communication, emails, anything of that nature, oral or otherwise. After the public hearing, you can receive information from your staff, from your attorney, from your consultants, but it generally has to be not new information, but rather a consideration of information in the record that's been placed before you. You have to be careful on site plans to be timely. You got an automatic approval if you haven't made the decision within the 65-day period from the date of receipt of the application by the commission. Similarly, on subdivisions have an automatic approval component. If you don't decide, they're approved. It gets approved. So on those, you need to be careful. Reasons for your decision. You go through a difficult public hearing. This is where it happens. It's not on the easy ones. Okay? It's the ones which are difficult. And you have opponents, or you have interveners, or what have you, and you get to the end, and man, you have been put through hell through this process. You finally get to the point, you discuss it, you make a decision, and you breathe a sigh of relief, and then, boom, you say, we're done. You aren't done. Because if that's going to be appealed, the court is required to look at the reasons that have been given by the commission collectively, not just what somebody says, but collectively. What are the collective reasons for the commission for the decision it made? And if you state a reason, that's the reason the court is going to look at. Only state one, that's the one they're going to look at. So sometimes you say, let's get out of here, we'll put down, you know, does it met the regulations. That's going to be enough, okay? It met the regulations, okay? But be very, very careful that if there are discretionary aspects to the application, that you put down what are the reasons, and even to the extent of putting on the record, is this the collective reason of those commissioners who voted in favor of the application? It's a real pain, it takes time, but if you state a reason, then you better state reasons that the court can look at and say, that reason is supported by the record. It happens, you learn from the bad experiences you had, and I had one, a commission, an old line, and they went through, and the reason they gave was, it had to do with seasonal use and whether or not the people that occupied the property during the winter months, and they had a big hearing. It was a ZBA case, but they had a big hearing, and at the end, when they upheld the decision of the zoning enforcement officer saying it was seasonal, and they had not demonstrated they'd lived there all year long. The reason they gave for the decision is the property didn't meet the public health code. And the court came up and looked at it, they said, wait a minute, whether or not it met the public health code was not the basis on which they appealed to the ZBA. That reason does not have anything, no rational relationship to the decision they made. And I begged the court, I said, now's the time, the spirit, now's the time to overrule that decision, or to make an exception to it. Take a look at the record. The record was full of information that supported the decision. The court said, nah, that's a rule, that's the reason they gave. So be extremely careful about that.
Excuse me, I got a quick question.
Sure.
Does that reason have to be included in the motion to approve or deny?
Yeah, it doesn't have to be in the motion, okay? If the motion is made to approve or deny, okay? Once the motion is made, it would be appropriate then, all right, would the maker of the motion or the proponents please state for the record the reason for the for their adoption of the motion. Okay, the reasons for it. It met the terms of on the special exception. Meets the terms of the regulation. It's an appropriate use for the property which is in question. It has met all the standards, general standards for the use, and it meets the special standards for that particular use in that location. Do the other members concur in those reasons? And if in the record it says yes, I think you're good. It's probably easier to do it after you make the motion, and then just make sure, because the reasons may be different. But if you get those, so identify what are the collective. Someone say, you know, I don't think it's the best place for it, but I voted in favor of it because I think it's still, and our regulations say they can have it there, and I'm in favor of it. So that's okay. That's okay as long as you still have.
So you would really like to cite the specific elements of the record which support that decision?
That's correct. That's correct, yeah. Because that's what, because what the judge is supposed to do, take a look at the reasons, And then the lawyers are gonna get them out of the transcript and documents, what are the things that support that decision. It's the substantial evidence rule, okay? Does the record have substantial evidence to support the decision? Substantial evidence, it's far less than beyond a reasonable doubt. It's not even a preponderance of the evidence, it's simply substantial evidence. Is there a basis for their decision? Under miscellaneous, I put a bunch of things, if you just take a look at them, because most of them I think you know, or the stuff is fairly self-explanatory. And again, because I got 5 minutes, so I want to, if somebody has questions on it, we can certainly get back to them. You're a planning and zoning commission, you know that. You got zoning regulations, which is your zoning function. You have subdivision regulations, which is your planning function. Just like under 8-2, it tells you what you can do with zoning commission members. Section 8-25 tells you what you can do on subdivision regulations. And again, take a look at that section. It's very similar to 8-2. Keep on adding incremental stuff that you need to consider. As planners, you do, just like you do as zoners, you adopt regulations, not what you think in general about how property ought to be developed. You adopt regulations. You put into those regulations how subdivision property ought to be handled. You have because it's a subdivision, you get some additional powers. You get the power of adoption of things such as open space requirements, critical open space requirements, because it's been found to be constitutional. It constitutes a limitation on the density of the development. You can't put more stringent requirements in terms of lot area or the like than you have in your zoning regulation. You can't do it in a subdivision. Usually this isn't a problem for a combined commission. But keep in mind that under the subdivision, the one area where you now, in the development of property, have the additional power, so to speak, is in the open space aspects of a subdivision. The other function of your planning aspect is the development or plan of conservation and development. And I just went through up in Chester and got a real education because there was a private applicant to amend the plan of conservation and development, which is very unusual. And so we had to take a look at the statute on, I did, representing the commission, on what was involved in amending the plan of conservation and development or adopting a plan of conservation and development. Okay, has to be done at least every 10 years. A lot of communities, their plan has not been formally adopted. They have sections which have been adopted, but the plan itself, or the amendment to the plan, has not been formally adopted in the appropriate legal way. I bet you, from my experience, I think a lot of towns are out of compliance on how they adopt their plan of conservation and development. So it's fertile ground to take a look at, just to see where you are, because it really is an important document, and it really shouldn't be sloughed over. Public hearings, procedures at public hearings, notices, decision-making on the planning side are essentially the same as on the zoning side. The critical difference is the automatic approval provision. If you don't act on a subdivision within the specified period of time, then you have problems. In subdivisions, and also I think under special exceptions, conditions, the use of conditions are a very valuable tool for the commission. Courts have said yes, conditions are allowed. You can condition it, particularly if the condition is integral to the decision. That is, the condition is necessary for you to grant approval. I wouldn't grant approval, I wouldn't approve this unless this condition were adopted. That should be specified on the record. That's it. I think I just about got my time.
Yes. Okay, we're gonna open it up to questions, and I'll start off by asking one question that's sort of swishing around my head here. On a site plan, two things. It doesn't have to be a public hearing. In fact, is it recommended that it not be at a public hearing? The public cannot participate in a site plan application approval or disapproval?
That's a judgment call by the commission. And personally, I think the better practice is not to allow public participation on a site plan review. It is not a public hearing, okay? And the only reason I say that, the commission can say, will we allow so-and-so from the public to provide information to the commission. The commission, I think, can decide, yep, I'll let them do it. But where do you draw the line? When do you allow it, and where do you draw the line? On a site plan, I think the remedy for the person is that they can submit any written material for, to be considered by the commission in the site plan review.
The second part of the question on the site plan is if a site plan meets all of the requirements, setbacks, what they're doing, where they're doing it, but still, in the judgment of the commission, it doesn't meet the safety, health, standard of the community, it can still be denied, correct?
I'm going to say not on a general health, safety, welfare basis. You can't, if I come in on a site plan and I meet all your regulations for that particular use, it's a permitted use in the zone by site plan, that I meet the area requirement for lot, I meet the setback requirements, I meet whatever are the other requirements, okay? You cannot simply say, I move to deny this on a safety consideration, that the traffic on the roadway is too intense, that this is a disaster waiting to happen. if you deny it on that basis, if the applicant appeals, I think they would be successful. Because there's a lot of case law which says, if you zoned it for that use, and if you set up those parameters in your regulations, then you've told him that as long as he complies, that's a legal use for his property. If you think there's health and safety problems, then you better rezone that area. I mean, that's gonna be the short answer.
I was thinking in specific situations where there are different factors that come into play, not general traffic, but specific issues pertaining to the use, then would you not be still within your discretion to deny it on the health, safety, and welfare of the community stand?
No, I don't think so. I think what you probably ought to do is before that application comes in, all right, is change the regulation before the application is filed. Make it a special exception use. Because it's under the special exception, under the special standards where you get into your health and safety factors as to whether the use is appropriate for that location. That's that Whisper Winds case. Okay, you could say, you could deny it, although it meets the bulk standards, it does not meet the special standards. Take a look at your regs, traffic adjustment, harmony, traffic flow. You've got all the reasons in there. They're stated in generic terms. But you have the reasons, and you'd have to state those reasons specifically. Okay, you state them specifically. Then, if that motion prevails, okay, where in the record is it that those health and safety factors make that use inappropriate for that location? In this stuff, and some of the mentioning, if you're going to rely upon your own knowledge of the area, and if someone is going to say, look, I have knowledge of that area, that location is a health, safety, whatever it may be the reason, problem, state it on the record. State it on the record and give the applicant, the opportunity to rebut that. I have a concern about your application. It's a site plan application, but I have a concern, for this reason. You're still going to be in trouble, okay? Special exception, you probably are going to be okay if you have said, here's the problem during the public hearing. Convince me I am wrong. Provide me with information that convinces me and the other commission members who may agree with me. Rebut the presumption or the point of view that I have. But there's the case law as a critical difference between site plan and special exception. And even special exceptions, they're permitted. It's a permitted use in the zone. There's a lot of cases which say if you permit it, it's got to go forward. It was a subdivision case, a Pansy Road case in Fairfield. And it was a 7-lot subdivision. And had a road, a little cul-de-sac coming in for 7 lots, but it was across from a school. and it was on a busy road, and there was another intersection fairly near it. And they turned it down on the basis that there was too much traffic on that road, and because there wasn't for the school an entrance way, all the school buses came in front, and they went to basically Superior Court and the Supreme Court, and they said, nope, can't deny it for that reason. It meets the regulations. You zoned it that way. The subdivision meets the zoning. You can't turn it down for that.
When we get into a situation where we don't have professional help to support a case and say, for instance, with traffic, we have a traffic study, how much backing do we have then if the traffic study comes back and says that there's issues? And do we just go in and apply conditions and that's all we can do?
Well, yeah, and you always think about specific cases, and I know you have experience with that. It's very difficult. Let me put it that way, because I think what you need to do is, if as a commission you still have a concern that regardless of what an environmental engineer, a traffic engineer, a wildlife biologist, or whatever it may say, if you say, I don't think that makes sense, and you should engage your own consultant to give you a report. It's going to cost you money. It's going to come out of your budget. But if you feel, I need some help, hopefully you would have already invoked your review fees, so you can make the applicant pay for that. But I think that's what you need to do. If you think there's going to be, early on, there's going to be traffic, environment, question, get review fees.
So this is something you're suggesting takes place in the land use office before it comes to us then?
I think under your regulations, I think you've done a pretty good job about under recommending pre-application procedures. And I think you do have a provision whereby you have specific, a determination can be made early in the process as to what sort of information you're going to need.
Would
So,
you make that a condition of acceptance of the application? You accept it?
You gotta take a look at the regs as to how that works. Because I don't think you make it as a condition of the acceptance, okay? One of the statements in here, refusing to accept an application as incomplete, is very dangerous, okay? You have to act on what's presented to you. Take a look at the regs, because I think you do have a procedure where you can get review fees early on. But
Early on, but what if you're in the midst of a hearing and the issue comes up, they have an expert, you don't have an expert on that particular.
you didn't get review fees or what have you.
Right, can you then impose it at that level, at that stage?
I think I'd have to take a look at the ordinance. I don't think you can impose it then, but I think that's what I'm saying. If you haven't gotten them early on, now you say, oh, gee, I wish I never dreamed that.
Well, how would you know what they're gonna, how would you know what they're gonna come up with until you have the public hearing, and what experts are gonna have, and
It
what
would be,
presentation they make?
yeah, if you take a look at it, like the regulations that have been adopted, I can't remember, and you may know, there isn't there a requirement that the application be, in order to get on and to be received at a meeting, there's a time period to before the clock starts. And the purpose of that time period is I think there's also, isn't there a requirement?
Well, what we have is a requirement that it be the Friday, a week before the meeting, that it has to be received. That it has to be entered to the land use office.
Okay. And is there not a requirement someplace in there that they provide you with the expert testimony, a list of the...
It has to be a list of experts, yes.
Okay, so what you, and remember, you have, usually this is gonna come up in special exception or subdivision context, not site plan. You have 65 days before you before you have to commence your public hearing. And during that period of time, that's when you take a look at and find out what you're going to need, okay? Invoke the fees before you even start the public hearing process. Before you get into that, so you've got the fees, you can commence the public hearing, and if you haven't gotten the reports that you need from whoever you've got them, you continue that public hearing until you've got it. You've got to complete it within 35 days, unless they consent to an extension. So you've got basically you've got 100 days.
So you can continue the public hearing for the purpose of obtaining this additional information for review,
Correct.
which the applicant can
Correct.
be made to pay for.
Correct.
Seems like this is where, we've talked about this in the past, we've fallen down on that area. We need
Yeah.
expert advice and things, and we're just up against the wire in terms of time getting it.
Well,
There is a tendency, I think, in Clinton to schedule your public hearings pretty much right away, administratively almost.
Well, there's a review process at the outset, and they go through the application, the review committee.
Yep.
In theory, goes through the application and makes sure that everything that's necessary is in the packet. But at times, it's not, and the hearing is still scheduled, and they bring it at the hearing, the public hearing. But what I'm saying is, if members of the commission are unsure about some piece of evidence or an expert's opinion, and at that point raise the issue, say, well, gee, I'm uncomfortable, I'd like to hear from an expert that we engage on this point, is there a method still available to us to do so, provided the timeline
Yeah.
is met?
You've got that, you basically have that 100-day period, 65 days before you commence the public hearing.
And then I assume it's subject to vote, because if one commissioner has a particular concern, if the rest of the commission doesn't have the same concern, then obviously that's not gonna work. Right, so say a commissioner raises the issue and by motion resolves to get expert review payable by the applicant, and you put it to a vote, and it fails, that's the end of the story. Or do you even put it to a vote? I guess that's my question.
Yep. My experience is very much in Old Saybrook, where they have the same sort of a similar type. They call it Ordinance 71 review fees. Okay, they have land use staff, and what the decision about when I file an application, right? The public hearing is not set until we have really determined whether they're gonna invoke review fees. When will their reports be available to the commission on my application? Because I, as an applicant, I want to be able to respond to the commission stuff at the public hearing for my client. So it's really in both the commission's interest and ultimately the applicant's interest that at that first meeting when you get the application, if it is filed at the last minute, you basically have 10 days before it gets on to the, it's formally received to start the clock. If you have not been able to determine in that period of time, don't schedule that public hearing until you have, at least at your first meeting, made a determination as to whether you're going to need review fees. And if the commission, when you said to make sure you're prepared, okay, one of the things commission members ought to be is familiar with the applications that are being made so that they can at least make that judgment. If they cannot at that meeting, they say, look, I haven't had an opportunity to really look at it, I don't know how complex, I'm not prepared to make them pony up the review fees at this point. Well, then continue the matter before you schedule a public hearing.
And that's different than the way we've been doing it. We tend to do them simultaneously, just as a matter of course, so that would be a change in our behavior.
And Old Saybrook has a decided advantage because they have a professional planning staff that reviews the applications and says, well, I think in this application, we should probably have, and generally, to my knowledge, the commission goes along with the recommendations of the planner.
Yes and no, okay. Yes, they have a planner, zoning enforcement officer, and they have a environmental person on the wetlands end. So they do have more staff available to be making that sort of thing, okay? But I think that your staff is capable of at least identifying those applications where you may need professional advice. And I think that you can ask them, when an application comes in, is to, you have a review committee that within that 10-day period?
Yes.
Yes, we do.
No, the review comes after we accept it,
It does?
after we receive it, yes. The
Okay.
review is after we receive, isn't it?
No, you've been reviewing it before the meetings.
Yeah, I think we review it before the,
You review it before it comes
Before
before
it's
the full
accepted.
commission.
That's right.
pretty sure that's the,
Okay.
I'm pretty sure that's right.
And we've always had a problem in that review process. The only time we didn't have that problem was what happens is that the review process is a checklist. And it's a substantive checklist. It's not a planning checklist.
Yep, gotcha. I know exactly.
And the staff
Did
is
you have
capable
12
of
copies?
doing that substantive review. Is the survey there, is this paper there, but not raising the planning questions. That's the serious problem.
That's where we're going.
It's absolutely a problem that we have because logistically, we can't do it. So it comes before the commission at the public hearing. And immediately, if there's a stress point, the commission, one commissioner or even more than one commissioner will raise the issue. Generally, it's out.
Don't do it at the public hearing. You got 65 days.
But I'm saying
65 days.
If we're not satisfied, or somebody is not satisfied at the public hearing, are you saying we cannot request a review by a professional at their
I'll have
expense?
to, I have to take a look at the way your regulations are set up on that. I just couldn't answer that
Okay,
right now.
I
I
put it on
don't-
the list because
Yeah, I
that is a
don't think
very
it's-
The
important.
problem is we often don't even see that evidence until the public hearing takes place. Scheduling the public hearing right away, sometimes the applicant's professionals haven't produced their report yet. And we've scheduled the public hearing, 30 days in advance of that.
Now, I'll tell you that you should not schedule your public hearing until you know what you've got as far as an application is concerned.
I have a question, just based on something Alan just said, was that he said that he referred to the planning side. Now, we can't make a judgment based on the planning side on this, because we're administrative when we're looking at something. Planning would be our legislative side, correct?
No, planning is not legislative.
Yeah. Subdivisions,
Well, on a subdivision, that's different.
administrative,
A special exception.
special exception.
Right, but on a site plan,
Site plan is zoning, special exception is zoning.
right,
Okay, but I think the timing issue is, and I think the problem in an attempt to be able to give the applicants early kind of action on their applications. The scheduling of the public hearing before you really have a full understanding of whether or not you're going to need any expert advice on the application is a mistake. Because then you're in that dilemma where you start the public hearing, and now you got, your 65 days has been used up without being used. Because you start your public hearing, you now have, your window now is 35 days unless the applicant agrees to an extension. So you've wasted the period of time.
What it boils down to is we're greatly dependent on staff to make those decisions for us ahead of time. So when we're presented with the applicant's application at the public hearing, we're behind the eight ball in many instances.
Don't schedule the public hearing. Don't schedule the public hearing.
You have 65 days from the time.
From the time the clock starts, which is the date of the meeting after the application has been
Well,
filed.
who's going to make that decision as to whether a package is complete?
The commission.
How, practically speaking? I mean, we have.
That's what the review, I think that's what the review,
That's what the review's supposed to
the
do.
review committee looks at it.
Two different questions as to completeness
Right.
and the scheduling of the public hearing. Two different questions. I think one, as you say, is more of a checklist
Right.
to determine whether all the materials required under the regulations have been provided. That's question number one.
That's what we seem to do almost exclusively.
Right.
The other aspect. doesn't
That's what
come
I'm
into play.
saying is, if you don't feel that you have the staff that can make that decision, then it's gonna have to, that you gotta bite the bullet, and the commission is gonna have to make that decision. When do they make it? They make it not at the public hearing. Make it at the first time that item appears on the agenda. Because I think it ought to come up on your agenda, special exception application, John Jones for a,
When we accept the application, you're saying it should take place at that stage, not when we already schedule a public hearing on that application.
correct.
And the review process should be more thorough. I mean, I have to acknowledge that, I mean, having been on the review committee, I don't think we were as thorough as we should have been.
Well, the review process probably should be more thorough, it should have more involvement from commission members rather than exclusively staff.
Well, it's, you know, it's one or two co-chairs of the review committee.
Right.
But that's still not a problem. And let me tell you, just from my experience where you have to have so many, a document is part of the CAM application, I mean, I do applications all the time. And the application is filed, all right? As long, and I deal with the land use office, you need, out of the, 53 things I gotta file, 51 and 42. As long as I get them in the office before the public hearing, as long as they're on file with the application, long before any of the notices go out to the public saying, the application is on file in the land use office, come in and take a look. As long as those things are met, there is no harm to the public. Okay, there's no harm done. So don't schedule the public hearing. When you get to your first meeting, okay, if the review committee tells you, you know, we didn't really get, you know, a chance to take a look to make sure the application is fully complete, accept the application. There really is no procedure to, quote, accept an application or reject an application for being incomplete.
No, it's we receive it, period.
Period.
Receive it.
Okay. You can, at that point, determine, you know, basically, is this application complete so that in fairness to the applicant and to the public, we can schedule a public hearing? And all the materials for us to make a decision are there. So make a determination as to whether it is sufficiently complete to schedule your public hearing. Just accept it.
Could I simplify that and say, you know, basically, we shouldn't, in that, when we receive, we should not schedule a public hearing if it looks like it's a complicated application, because we're probably going to want to consider bringing in an outside expert.
Absolutely.
And so we would have a month to look at it till our next meeting, and at the next meeting, be able to discuss whether we want the experts and then schedule a public hearing. And still make our 65 days.
Absolutely.
That's what you're saying?
Absolutely.
But there's been so
I got
many-
So be mindful of that.
There's
No,
been so
you're
many
on.
applications where I
Schedule.
personally felt like I had a gun against my head in terms of getting this application either approved or denied, and there's just not enough information, and I don't know if anybody else has felt that way, but it's been very, very uncomfortable. some of the
Make
situations.
our townspeople, Julian, town
Our staff.
staff.
Can we go back to a site plan approval?
Yeah.
Because, you know, there are regulations, and the question is, does it meet the regulations? But within a site plan, there are a lot of complexities that you can't always anticipate. Where, for example, and a classic example is access and egress from the site. And it raises traffic flow questions. Is there any latitude in that situation to bring that element, which I would consider a planning element, into consideration?
Very, very little.
What's the little part then?
The little part is to say to take a look at, under your general standards, and even for site plans, and determine if you get a report from your fire department that you can't get an emergency vehicle onto the property, okay? That because the turning radius is not adequate. Those are the little things, okay? The little things. And being on the other
So
side.
that would be the engineer, the health district, and the fire, in our case.
Correct.
Those are the three things.
Correct. And again, speaking from experience, I face it on the other side, the no good commission members, they don't like it, and so they're nitpicking me on a turning radius for the width of you've got regulations, and boy, sometimes on site plans, boy, you apply them, that's your little bit of discretion, I think. You just can't say, this is a lousy site plan. The entrance, the egress, sight lines, you better document it, that there is a demonstrated safety, because that tree prevents anyone coming out of that exit from seeing beyond 5 feet. Better have
By
that.
that
in
you
the
mean
record.
expert testimony, not your own personal opinion.
If you're gonna do your own personal opinion, disclose it to the applicant, okay? And you better be pretty certain of what you're doing. That there is this tree, okay, that it prevents. That from my own observation, that tree coming out of that intersection at eye level would prevent you from seeing oncoming traffic. And I want you to, unless you are prepared to provide this commission with evidence that there isn't a sight line problem, I, as a commission member, am prepared to vote against it. But on site plan stuff, you're very, very limited.
The issue is frequently a traffic issue. Is that something we don't cover? And we refer it to the fire marshal, basically, correct? Could we refer something like that to the traffic commission?
Oh, absolutely. Now, the case law, here's the thing, you say how you get
How you
around.
do it, right.
How you get around this stuff. I feel terrible for all my clients I represent, giving you this sort of information. But what it is, the case law is saying, here's the road.
You represent too.
Here's the road, right, here's the road, right? Case law is saying, stuff on that road, you've already zoned this commercial. If there is a problem with internal circulation here, okay, that's within your jurisdiction, your standards under your site plan. But if particularly you got a lot of state roads, if they're fine with it, you've got virtually zero, okay? You better find some on-site problems. On-site circulation problems, backing vehicles once they get in there, how are they gonna make a turn within the property to get that ambulance back out in time? That stuff on that site plan, that's where your main area of ability to control or deny is located.
And Alan, you're suggesting adding additional recruitment?
I don't know, I was asking that question.
And if now's the time, if you go through and you take a look at some of your site plan stuff and just look at worst case scenario and then decide whether or not it's worthwhile simply to make that a special exception as opposed to a site plan application.
Can I go back to the consultants? Something that is in, I guess, the appendix of fees says that prior to or contemporaneous with the filing of an applicant, the applicant shall advise the commission in writing, as professional evidence by way of testimony certification that it intends to submit.
That's what I'm.
Such written statement, including traffic, hydrology, and then the commission may charge fees in addition to the base fee to do their own, to provide their own independent analysis.
That's what I'm talking about, right? That is your mechanism to get the fees. They're supposed to do that when the application is being filed, so you have the information of what they're bringing in to assist you to decide, okay, what are we gonna need?
And I recall one application we had where the town engineer had said we had 60-something issues that had been cleared up, but then said maybe you want to get your own independent evaluation of this thing. We didn't do it.
It was past the point, though, in
But-
the public hearing stage.
That was at the public hearing stage.
Well, I know, here we have an engineer who's speaking for the applicant, saying, these are all taken care of, but maybe you ought to have somebody else look at it.
Well, I remember that particular instance, but we've had that problem come up before. Not as dramatic as that one was perhaps, but it has come up. Now I think we have a potential plan to put into play, should it happen again. When the application is received, if the packet is incomplete, that's easy, but if at that stage, a member raises an issue and says, gee, I think we need a traffic study for this particular application, that's when we impose it before.
Before you
we
set your
schedule a
public hearing.
So we will not receive it and schedule a public hearing. I guess we don't receive it until we get that.
No,
You
Yeah.
have to receive it.
you receive it when it's filed. Guy comes in and files, your application form and signs it and pays the fee and, most of the stuff is not there, okay? What the case law is saying is don't say this is denied as being incomplete. You just say to the guy, you filed it. Okay, if you want us to go ahead and file this, we're telling you it's missing all these things. It's going to be denied. It can't be approved because it's missing these things. You want us to go ahead with it? Fine. Most applicants will say, okay, I'm not filing it. Take it out and don't have it received at the meeting. However, if that doesn't happen, it gets received at the meeting, okay? You do not deny it. You do not make a decision whether to, quote, accept it.
We'll receive it, we'll first receive it.
It's received automatically by
At a regular
statute.
meeting, we receive the application,
And the
You
clock
see.
starts.
and the clock starts.
So you
Now,
have 65 days to have a
so
public hearing.
what you have now is you decide, take a look at it, and if you say, advise the applicant that the application is incomplete and will be denied if these items are not produced as required under regulations, number one. Number two, take a look at it and determine whether or not you think you are going to need any review fees from looking at the application. It'll be rare you get an application that's so incomplete that you can't tell whether or not you're going to need review fees.
I think our biggest problem is that the applications come in, they're complete possibly the day before, and we don't have enough time to review the documents, and we've been accepting them and then scheduling the public hearing.
Yeah.
We've just been snowballing it.
Yeah, just get into the habit that you don't schedule the public hearing unless somebody has done so much of their homework by taking advantage of your regulations. We say, come in with a preliminary application, go to, staff, give us stuff in advance, let us look at it, correct any engineering issues. Unless, and if somebody does all their homework, and you've looked at it, it's a completed application, okay, and they've told you what experts are going to use, okay, probably the only thing you need to do at that point is to decide whether you're going to need your own expert. But if it's so simple, we aren't going to have any experts, it's just our site plan, it's pretty simple, and you take a look at it, that would probably be the only time you would say, yep, we can schedule this for a public hearing. But it should be the commission's decision after it's looked at. And you may find that, there's a lot of them, you say, yeah, we can, it's done, they did their job. You can schedule it for next month.
But the simple ones, of course, are site plan, which we generally don't have public hearings on.
Correct. Okay, but you don't decide, you got 5 days to decide them,
Yeah.
okay? And if if you need expert, advice, it should be rare on a site plan. But if you say, in this one, we need traffic or we need environmental because it's right next to something really sensitive, gotta make that decision at your, at that meeting that it's received. Okay? And you are gonna have to make the decision and make sure you get that report from your expert by your next meeting, because now you don't wanna have to decide it at your next meeting.
You don't want to get the report on the meeting, on the 65th day.
You don't wanna get it on, 2 months after you've received it. You wanna get it 1 month after you've received it.
I have to confess, this idea of a comprehensive plan and a plan of conservation development is new to me. I don't know if it's new to anybody else. But I don't quite understand, how both of these get passed or how they get adopted. Who adopts them? What kind of public hearings do you need? I've never heard of the comprehensive plan. Is that basically our zoning regulations?
It's our regulations.
It's
a
a,
land use map.
So it's basically our regulations, when you're saying comprehensive, and the map, so that's the comprehensive plan. And the plan of conservation development, does the comprehensive plan come out of the plan of conservation development? Is it supposed to reflect?
it's supposed to,
Okay.
because you're supposed to, in adopting regulations, have them in a consistent manner, and you're supposed to consider the plan of conservation and development in adopting your regulations.
Your comprehensive plan.
The plan of you are supposed to adopt, you're supposed to consider the plan of conservation and development when you adopt regulations. And if
Which is your comprehensive plan.
Regulations.
That's part of your
Regulations.
comprehensive plan.
Which are, and if you do that, if you look at it and you follow that and your regulations are a coherent whole, then you have, the adoption of a regulation will be consistent with your comprehensive plan. It's gobbledygook, believe me.
Yeah, usually the comprehensive plan includes within it a future land use plan. The future land use plan is, but you haven't.
Plan of conservation
And development includes the future land use plan.
Correct.
But you have a land use plan that's a part of the regulations. It's fundamentally the land use map and all the zoning regulations. So initially, when you adopt that new plan, there's an inconsistency. That's why you adopt the plan to say, well, if we're changing our objectives for land use in certain areas, we need to bring the regulations and the land use map into consistency. And they're supposed to be guides.
If you read section 8-23, okay? And this is the one, preparation, amendment, or adoption of plan of conservation and development, okay? It is a terribly written statute, okay? I'm just gonna show you, okay? It starts here, shows all these things, tells you the commission may appoint one or more special committees. In preparing the plan, the commission shall consider the following, so it tells you the community development action plan, if any, blah, blah, blah. Such plan of conservation development shall be a statement of policy goals and standards. And it goes through a bunch of other things. You're supposed to take a look at the state plan of conservation and development. I finally looked at it because, and I said, and that's a bunch of gobbledygook itself. Then it says, you should look for your regional plan of development. We don't have a regional plan of development yet because they're still working on it, because our regional planning agencies now became the Council of Governments, okay? So they say, we aren't looking at it, but we'll tell you what we think. And that is, satisfies the statute.
Yeah, I'm looking at the statute now, I mean, it looks like you do, the timeframes, and it goes 65 days, and 35 days, and you do
It's
something
all,
else.
it's all over the place.
Right, so, but then the end, after having public hearings and doing all of this, and then we adopt it.
Yep, you adopt it, but remember, and this is where the things get to be a problem. In order to adopt it, you have to have it published on your website for at least 35 days before the public hearing on adoption. You will have to have referred it to the Board of Selectmen at least 65 days before the public hearing on adoption. The Board of Selectmen then can schedule any number of public hearings on the adoption, and then they can vote to either recommend it or deny it or something, and then you need a supermajority vote in order to adopt any provision which they have said you can't adopt.
Planning and zoning needs a supermajority too.
Planning and zoning would need a supermajority in order to adopt any provision which the Board of Selectmen has recommended denial for, okay? You
This
got
is all
these
new.
times. These are all public,
And this is all new, because it was never adopted by, reviewed by the Board of Selectmen in the past. That was not required, but the idea was to try to get them to buy in, so they developed capital improvement plans that were based on the town plan of conservation and development.
You're not alone. You're not
Every
alone.
municipality.
You're not alone.
Well, in the past, we've given it to them, but they don't schedule any public hearings, they don't.
They don't have to.
They don't
In the
have
past, there
to.
was
They're not
nothing in the-
required to.
There was nothing in the statute. Now,
No,
there
they're not.
is, the statute's changed for planning and zoning.
But they're still not required to, they have the right, they are not required.
We have to refer it to them.
Right, we have to refer it to them, but that's.
You gotta refer it to them, and it's gotta be at least 65 days before you schedule a public hearing. Now, it doesn't say it in the statute, but in my opinion, you've got to notify that as to when the public hearing's gonna be, so they know by when they need to report, okay? Now, and that's the public hearing on adoption. Look at the statute, and the statute talks about the commission may hold, your commission, one or more public hearings. These are essentially informational public hearings. But the public hearing on adoption, you've got to specifically meet these time requirements when you do that.
So all of the things we've been doing, like, for the plan of conservation and development now, where we're having public meetings, those are the pre-adoption public hearings.
They're not even
Correct.
hearings. They're not mandated public hearings.
Well, they're meetings, though.
They're meetings.
They're meetings, yes.
To,
The statute says you may have public, any one or public hearings, okay? Those public hearings do not need to meet the statutory requirements under 8-7, whatever. But the hearing on adoption does, filing with the town clerk, newspaper notification, et cetera, et cetera. So you're okay. Whether they call it a public hearing or a meeting is pretty much irrelevant, but the one on adoption, an adoption of everything or amendments to it. In other words, you don't have to adopt it all at once, you just, you could be adopting different sections piecemeal.
Does that bring us to a question on our public meeting for the planning conservation development is the number of persons attending?
we're having a charrette on January, to be specific, on January 18th, where members' participation is encouraged. We anticipate that there will be several members sitting there at any one time. This is to take place between 10 and 2:30, I believe, right?
Say 10 to 2, setup, takedown is,
Right, so how do we handle that? Because that would be a meeting, because we would have a quorum.
and just to explain, the setup will be, there'll be 4 areas within this room where different members will be participating with the public, so it won't be a forum where anybody's sitting at one table.
Okay. You're okay. Do whatever you want. When I say that, I'm not being facetious, okay? You don't have to publicize it because it is not a statutory public hearing requiring notice. Under the plan of conservation, it says, you can hold any one or more public hearing. You can also hold meetings at which you allow the public to participate. It sounds to me like the easiest way, I think, for you to do this one is treat it as a plan of conservation and development public hearing.
Not a meeting?
Public hearing, without the need for a newspaper or any other
No
notices.
legal notice.
No legal notices. You could notify whatever way you want to.
We
Okay?
advertise it so we can get public participation.
Okay. It is also a meeting, as long as you're going to have members here who are, going to constitute a quorum, they're going to be here. So your easiest way is to then just notify it as a meeting, but just make no decisions. Make no decisions. As long as you make no decisions, you're fine.
So we don't have to keep minutes of anything.
So 8-23 is followed by 8-24.
Municipal improvements.
Right.
Yep.
So what does the Planning and Zoning Commission do when 8-24 is ignored? Or just procrastinated until basically brought to us as a fait accompli?
That's what they call a loaded question. Here's what I think, all right? 8-24 is mandatory, all right?
That doesn't mean it gets done.
It doesn't mean it gets done. It also says that even if, there's a section in here which says, even if you, notwithstanding the provisions of this section, the municipality may take final action approving an appropriation for any proposal prior to the approval of the proposal by the commission, the planning commission, pursuant to this section. So
it
right
basically
in
means-
here,
So it means nothing, right?
right in there, they gave them the out.
Right.
Okay, I don't write them, okay? But, so they gave them the out. So, what are you gonna do? I think the commission formally, if you find, wait a minute, this is a proposal for, it never was referred to us, send make a motion that the chairman notify the Board of Selectmen that this proposal was not referred to the Planning Commission as required under Section 8-24 of the Connecticut General Statute. The commission feels that it has a function to report to the legislative body on such a proposal, and that it's being denied the opportunity to perform its statutory function. Kindly refer any future proposal of this, under this section, to the Planning Commission. After you've done that, it's in the political, it's in the political.
Well, that begs another question, though. Who is the legislative function of the town? Clinton?
Town meeting.
Right.
town meeting, except where the charter has removed certain aspects from the town meeting as its legislative body to another entity such as the Board of Selectmen. I know,
And the Board of
I'm not an expert on your charter nor any charter, but there are provisions which limit the town meeting in Clinton, but it's the legislative body.
I'm gonna change pace altogether. For public relations purposes, when you're having a regular meeting, a regular monthly meeting, I know that certain boards, Board of Selectmen mainly, has a visitors section where they allow visitors to participate. Is there any prohibition to our doing something similar?
No,
So we could do that.
correct. You have, one of the things you mentioned, you have your bylaws. Your bylaws, and.
They're
yeah,
silent on that, I believe.
Yeah, but the.
There's an order
but
of
it-
business, I think.
But it does have an order of business in there, and I'm not sure whether in there they have comment from the public or not. If they don't,
But also, wouldn't, I mean, if you've had a public hearing and you've closed it, and now you invite visitors to speak at the beginning of a meeting, and they want to speak to something that you've already had a public hearing that's closed on, what do?
you just say it's inappropriate.
So you'd say that's out of order.
Yeah.
We
It's out of
closed
order.
that public
It's out of
hearing is
order.
closed.
Are you talking just general or other
I'm
general
talking in
meetings?
general. I'm not talking about on a specific application.
No, but we open a meeting, we have a meeting and we're going to make some decisions on that evening of
Yeah.
things that have been in a public hearing. The public hearing has been closed. And somebody who couldn't come to the public hearing or whatever says, I want to comment on
You
it.
guys get to it, boy, you better deny application number X, Y,
Right.
Z for the reasons, blah, blah, blah. That's out. I mean, if you did it, you would simply say that's
No,
out.
I'm thinking of a situation where you have a regular meeting, and there's a question, and somebody from the floor, member of the audience, would like to have a comment. Is that allowed or not, or is that just strictly our regular meeting and nobody
It's up
gets?
to you. It's up to you. You
As the
can
chairman,
do
I
it,
think
you can do it or
It's
not.
up to you.
But what does the order of business say? Is there a,
What's that?
what does the order of business say?
You as a commission can do it. Under your, because under your bylaws, it says, the order of business of your meeting.
Yeah, but I don't think we have that listed under the order of.
If you don't have it there, then,
It's call to order, roll call, designation of alternates, chair's comments, ZO report, new applications, old applications, committee reports, minutes, correspondence if received, bills if received, old business, new business, and adjournment. There is
okay,
no-
it isn't there, then my easy answer to you is no. Don't do it as chairman, because it isn't under your bylaws. But if you think that it's a good idea to do it at some meeting, you can just put it on the agenda to amend the bylaws to provide a period of public comment in the order of business.
It might be beneficial on occasion to see what the community's thinking on anything in particular, so, I don't know.
I mean, and have it just be at a specific point in the meeting.
You hate to have somebody from the public want to raise a question or want to make a comment, you say, nope, not allowed, because that immediately puts a barrier between.
Yeah, the only place, if you didn't have it under there, you could probably waive the rules. I think you could say to the commission, you know, person from the public here would like to comment, I'd like to waive, the commission to authorize me to waive the order of business to allow President Obama to speak to us for a moment, and then we'll.
Maybe put them under correspondence.
But we're after,
Yeah.
yeah, I think.
There's some discretion,
The
like you
commission,
said.
yeah, the commission could.
You don't want to have it get out of hand, though, because, Friday's our regular meeting.
Correct, correct.
Okay.
Personally, I think you do it by, if something comes up, you simply ask the commission to, to waive the order of business to allow this person to make some comment. Otherwise, there's nothing wrong with having quote gadflies, close quote. But I see in a number of commissions, more so boards of selectmen than planning and zoning commissions, but where they do have the public comment, it's basically the same people who want to come up and express certain gripes. And it's very difficult, if it's right in your order of business, to say, well, gee, I don't want to listen to this for the 18th meeting in a row. Well, wait a minute. Your order of business says the public is invited to speak. So I think I'd be inclined, leave it alone. If the appropriate time comes up, ask for a waiver of the rules, waiver of the order.
Yeah, I guess as a commission, we could vote to
Sure.
Add an
overrule it.
item.
Just allow comment, yeah.
On the issue of zoning enforcement, something that it's taken me a year to figure out, but I want to make sure I've got it right. We make the regulations. The CEO enforces the regulations.
Correct.
He enforces not only our regulations, but also the blight. He's not responsible to us for blight, because that's a
okay.
blight ordinance of the town. He had nothing to do with the blight ordinance. But he does report the blight to us.
Okay.
And he reports anything else. And then once he runs out of what he can do to get somebody to comply, he turns this over to you. And now it's in litigation. And that's kind of, and at some point you come back to us and say, well, we had to settle this, this is how we'd like to resolve this if it's something that we can't just, we don't win in effect. I mean, it's not something that we can win in court for whatever reason. Is that is there anything I'm missing in that scenario?
No. I think the important thing to understand is the zoning enforcement officer is, let me go back one step. The statute says that the commission shall establish a method of enforcement of the regulations. It doesn't have to be a zoning enforcement officer. A commission can itself appoint a member to enforce the regulations. That has happened on an interim basis in some towns. You, like most towns, you appoint a zoning enforcement officer or zoning compliance officer. Once you've done that, that individual has, by virtue of the appointment, a responsibility and discretion independent of what you may want. Okay? Very often, zoning enforcement officer will go to the commission, I got this problem, what to do? Well, go ahead. Technically, they have independent standing to enforce a regulation.
They have the
The
authority.
action is taken by the zoning enforcement officer. It's not taken by the planning and zoning commission. It's Thomas Lane, zoning enforcement officer, versus whoever would be the defendant. If there is a new appointee, you simply, make a motion to court that the named plaintiff is now the new zoning enforcement. It's independent. Okay. That settlement of matters relating to enforcement of the regulations, it should be the zoning enforcement officer who makes the determination as to how that case proceeds, whether it's settled or not settled or what have you. The zoning enforcement officer, and I have advised zoning enforcement officers in the towns that I represent. The zoning enforcement officer has the right to seek the advice and consult with anyone they deem proper in connection with the enforcement of regulations, including their attorney or the commission, with respect to how they exercise their discretion. They can consult, they can get advice, they should not take orders, because it's their judgment. Okay?
So we can't, that you're saying the commission cannot make recommendations?
You certainly can,
We can't.
okay? You say, and both specifically and generically. Specifically, we don't think the regulations concerning signs are being properly enforced. We have regulations, and everybody is violating them. We think that there should be enforcement of those regulations, or any other matter, okay? You can also, that's generic, okay, specific. I've got this case, you know, they've come in, they're applying for, you know, variance to allow them to do what a cease and desist order has been done. I think you know, it's been a couple of months, but I think I should wait. You could very well say, we don't think you should be waiting. We think you should be pursuing that more diligently. Okay? I think that's fine. But I don't think it's proper for you to say, by motion, we are directing you to take action against X, Y, Z.
The commission is, at least myself, have been approached by endless number of persons meeting on the commission and having regulations and saying, all right, there's these locations in town that are problematic, why isn't anything being done? We refer that to the CEO because they are specific, you're saying we can't do that, but we should.
No, you can refer it to the CEO, but I think more appropriately, you want to say to the person that, just like I said, the zoning enforcement officer has independent statutory authority. You should make a written complaint to the zoning enforcement officer, okay? If your complaint, you feel your complaint is not receiving proper consideration, alert the commission, because the commission is always able to exercise its administrative duty. You aren't telling him to take care of that complaint, but you are advising him that there has been a complaint to the commission that actions are not being taken. There has been a complaint to the commission that a specific matter has been brought up and that nothing has happened. And the commission, if the commission does think that there should be more effective or stringent enforcement, you can so advise the zoning enforcement officer. But I think you're got to be very careful of that, because it is independent. There are also, it's called 1983 federal lawsuits. Section 1980 of the federal
The civil rights?
civil rights. And civil rights are property rights. Violation of property rights, which are part of civil rights, under color of law. An official and a commission using their position to violate someone's civil rights, okay? Turn that around. okay? The commission told him to get me. That's why he brought this action against me. Singled me out. Everybody in town doing exactly what I'm doing. They singled me out because they wanted to get me. You can hear the story, you know, I mean.
Typically, though, what happens is members of the public will approach a commissioner and raise certain problem areas or problem property and complain, this isn't being done. And you're put in a position where you're now, in a sense, are being asked to answer for the CEO, who they misinterpret as being under your
Correct.
jurisdiction.
That's what I think you have to correct. You have to say, you know, the CEO under the statutes, he's got an independent position. You're gonna have to make your complaint to him. And I recommend, I think you can say, I recommend you make that complaint in writing.
Well,
Because
in
it
writing?
becomes,
Well, there's a
it becomes
complaint
a public
form
record.
on the website, there's a complaint form. Now, on the planning and zoning regulations, under enforcement, he can enforce the planning and zoning regulations on complaint or knowledge. So if he's not, if he knows
So
of
what
it,
constitutes a complaint? Can a person call him up and say, I am so-and-so, and such person is doing thus and thus?
and there also seems to be some ambiguity as to whether they respond to anonymous complaints or not. I mean, I've gotten, Julie said one thing, Tom said something else, so I'm not really sure.
Are you talking about blight though, or complaints?
I'm talking about zoning complaints. The blight complaints, by the blight ordinance, requires that the person be identified. First Selectman has said that if somebody comes to him and complains and doesn't want to be on there, he will go out and make the complaint on somebody else's behalf to get around that blight ordinance requirement. But I mean, that he knows who the person is that's complaining, but the person who's getting a complaint doesn't know who's complaining.
That's
Because they
why
don't
I
want-
say, I think you say to the person, put it in writing, because then there's no question as to whether a complaint has been made. It is a public record, number one. And one of the reasons for doing that is that the zoning, because this is my advice to zoning enforcement officers, that when you get a written complaint, that you should investigate it. And you also should tell the person who's the complainant that in order to bring an action, you may need to rely upon a sworn affidavit in order for you to bring an enforcement action. Because you are bringing the power of the government against an individual, and you should not be doing that without a reasonable basis. Now, a lot of times, complainants, they don't want to go that far.
No.
And if they don't want to go that far, why should you be, you know, that upset by it? If there's someone, you know, I don't want to go. If it's that important, then they ought to be able to put it in writing.
I think that's why they're trying to utilize the commissioners.
You bet. You bet.
I got a question. I've heard the argument that there's case law that if the town does not take enforcement action on a deficiency in an application for up to like 3 years or something, that by default it's automatically deemed approved.
Yes.
Like, for instance, if we approve an
8-13A says it used to say, any building which violates area setback or other requirements, and no enforcement action has been brought within 3 years, that it shall be deemed a non-conforming use. Okay? It slips through the crack. It's a building, not the use, but the building, okay? Goes on the lot, okay? And it violates the setback. It's been there for 3 years, for whatever reason. Then building, it's protected. Now, they just amended that statute, and I think it was, amendment went right through without a problem to change it from building to structure or improvement. Okay? Now you think about it, a building, that which is enclosed, it's very really difficult for somebody to go 3 years to have a building which doesn't, didn't have to have a zoning permit, didn't have to have some sort of a plan showing that it met the regulations. Somebody goes out there, puts up a deck, okay, puts up a shed, puts up anything else, and if nobody catches it, and if they're my clients and they ask me, they aren't from Clinton, I'm gonna say, get a picture, date it, okay, and just hang on to it, okay? Because 3 years from now, when they come and say, wait a minute, your deck is in the setback, you say, 13A, the non-conforming use.
How about for specific uses, is there a time frame for use?
Now, uses, that's the one thing, somebody in their building has been, for example, suddenly the single-family house is a 3-family house, and it's been that way for 25 years now, okay? Finally, they figured out that's use.
That's
It's
use.
the use of the building.
So that's still,
not time protection.
What about a condition of approval? Let's say that we approved an application and we said, you have to put up a fence and gooseberry trees, or, whatever we come up with, and they don't complete that, and it's been, let's say, 3 years.
That statute does not apply
Okay.
to that.
So it's a statute, it's not case law.
The one you mentioned, the 3 years specific,
Okay.
there's one specific statute on that. There's case law regarding enforcement or non-enforcement. And what I thought you were getting to, if no enforcement action is taken, can an individual bring an enforcement action? They can't, but they can go to court, but they have to demonstrate that they have made an effort to have the town enforce the regulations, and this is where they don't. Where this comes up, where the neighbor comes in and says they're violating the regulation, and the CEO says, I don't interpret it that way, so I'm not gonna bring a cease and desist. No, you're wrong, you're crazy. Well, the answer is, okay, I will tell you in writing, I'm not going to enforce it because I do not think that's a violation of regulation. If you can convince a court, they can go and try to bring their own action.
does it have to go to court first, or can it go to zoning board of appeals?
No, it's got to go to
Go to
court.
court.
Okay, because they can go to, because what it is I had one recently where it's not a decision, simply that, I disagree with your interpretation, is not a decision which is appealable to the ZBA. It's kind of a non-action as opposed to an appealable decision. That's why they could go directly.
I got one question. 2 months ago, we had a condition, which was different from what we've usually been. If we have a full board here, 9 people, 3 alternates, or whatever it is, and a non-seated person who's, we're at a regulations meeting, has a comment or opinion of an application. During that one meeting the last couple of months ago, we were not able to comment on that application. In the past, we were able to comment on that application. That was driven by actually you, sir, when you were here at this meeting. And that is something that I wanted to get a feel for what we think we're going to need to do for the future.
Okay. Basically it's under case law that when is a person entitled to, a couple of things, to vote and to participate in the decision. Okay? And the case law says that if you, in order to vote, you have to either be the regular member, or you have to seated at the time the decision is made, and have either attended the public hearing or listened to it, okay? And once you get to that point as to who can vote on it, when you're in the decision-making session, only those people who are voters should be able to participate. That is, discuss, make a comment.
So
Okay?
you're concerned because you participated early on and weren't able to make comment
Right.
during the,
I wasn't seated
During the public hearing.
during the regulations here, our regular monthly meeting, when it's decision time to make a decision. And we're all commenting on the application. Prior to a couple months ago, we'll say, we were able to comment, participate, at least. I know I didn't have a vote, or a person would not have a vote. But at that time, I wasn't able to participate or make a recommendation or comment based on that application.
Because you weren't seated and because council advised that that couldn't be done anymore, or shouldn't be done.
Right.
I'll
That's
get
what
you-
changed.
I'll get you the case. I'll get you.
So you're standing by that opinion, that if you're not a seated member, not only can't you vote, but you can't participate.
That is correct.
Now, would that mean once a motion has been made, so that you're in the decision
No.
phase?
No.
Or prior to the motion?
No. The people who are going to vote are those people who meet the qualifications of the people entitled to vote. A, the member who has heard all the evidence, or if there is an alternate who is now seated for a regular member who has done all
You
that.
said that, but what I'm trying, you also
Once you
said.
get that, okay, who's now, public hearing's done, the matter's now up for decision. At that point, you should identify who are the people who are gonna vote,
Eligible to vote.
who are eligible to vote. And it's only those people who are eligible to vote who should express their opinion as to whether you should approve or deny.
That's even more restrictive than what you had said before.
so what if,
I may have, what did I say before?
Well, before it was just the alternates. Now now a full member who's not eligible to vote also shouldn't participate.
Yeah, I got out of that too, the slide.
So that's even more.
So if you hadn't heard, if you weren't at the public hearing or didn't hear it, you're not supposed to comment on it?
All right, yeah, I'm sorry, if probably you go through each one of these as specifically. If a member, all right, and it went through 3 public hearing sessions and it gets down to the vote, and the member is there at the meeting where you're gonna take a vote. You end the public hearing, and then you go through and you determine for the member, were you at each of the public hearings? No. I missed the second one. Have you reviewed the tape of the second one?
No.
No. You are not eligible to vote because you are not familiar with the entire record.
Vote or participate, you're saying.
Once he's not able to vote, then he can't participate either.
Once you've established eligibility.
Eligibility to vote you cannot then debate. Think about it. Why if I can't vote on it? So I should be able to jump around and convince you 5 guys that are able to vote on it? I'm not allowed because I can't vote because I'm not familiar with the matter, but I should be allowed to convince you as to how you ought to vote? See, I mean, that's
Is
that's
this a
the
recent
line.
case? Because we always have
Right,
that available.
yes, because what if we had a commission that everybody saw it, and I came about, and I could, we were all here during all the public hearings, and then one night, there wasn't, for the rules of the regular meeting, there wasn't a person there that's on the regular commission, and I do not get seated, but somebody else gets seated. I cannot participate in the discussion. That's where I'm getting at, the
Because you have all-
participation in the discussion. I know I can't vote. If I'm not seated, I'm not seated. But the participation is where I get,
See, theoretically, you could have an alternate be seated 2 or 3 times, and then when it comes time for the decision-making,
Right.
he's not seated.
He's not
because a
seated
regular
because
member's
a regular
there.
member came in,
everybody's.
and the regular member who didn't attend any meetings listened to the tapes.
Right, did what he did.
I'm not, I'm hypothetical.
Right.
Okay, I mean, that, because on mine, you know, I'm just giving a hypothetical.
Do some,
But how are we gonna keep track of that?
no, do
Well,
some,
first simple, you ask.
That's a good sheet there.
It's simple, yeah, you say who's eligible. The first thing you do when you address
Who's
the
eligible
item
to
on the
vote?
agenda is who's eligible to participate in this discussion and vote.
Yeah,
But
but
you have to-
most of the time, you're just doing regular members. We have all the regular members, okay. We don't, we have, you know, I mean, you have too many members, that's so, but so you have, you have 6 members, okay, that were there. Okay, now you say, okay, did you, all 6, either attend all the public hearing or listen to the tapes? And actually, you don't, you know, if you listen to the tapes, you're good, okay? All right, so I say, did you listen to the tapes? Familiarize with the entire application, listen to the tapes, okay? Now, if you then you're down to 5, whoops, one of the 6 members are at the meeting, you're down to 5, okay? Well, now you can go to your 3 alternates, all right? And you just start with them. How many of those alternates are eligible to vote under the same criteria? Were you there and did you review the tapes? Okay?
so that we seat them, we can seat the alternate?
If they're there, yes, you can.
So you can seat, for an ineligible member,
Correct.
an alternate can be seated for an ineligible member.
Have we done this?
What about a member that recuses himself?
Same
It's
thing.
ineligible.
He's ineligible.
So if somebody recuses himself or someone is ineligible, the chair can seat.
Well, I think the simple rule
If
is if
the
you're
alternate is
ineligible to
eligible.
vote, you can't participate in the decision. That's a
You can't
simple-
discuss, in a discussion.
If I can follow up on that, is the trigger the closing of the public hearing and the fact that we're getting ready to vote? Let's say we're in the first public meeting, and we know that there's gonna be no voting tonight. If a question comes up and I might have some input for, you know, I might have seen something in the road that I wanted to comment on, but I'm not seated, can I offer input even though it's just public hearings?
No, because the public hearing is closed.
No, we're
So
talking
we
about the
can't
public
We're talking
have-
about something without a public hearing.
Okay.
At a
So,
meeting.
At a meeting.
At a meeting, you, at the meeting, okay, let's say it's a site plan application, okay, no public hearing?
Right.
Because you.
There's gonna be no vote that night.
Okay.
So let's say there's gonna be,
The question kind of got changed. I think you said the public hearing is closed, but there's going to be no vote that night. Say, okay, we've heard a lot of stuff. Next meeting, we'll start our deliberations. You got 65 days to start. Next meeting, you're going to start. And say, I'd like to just make a comment on the application.
That wasn't actually my scenario. My scenario is, if it's the first public hearing, okay, so there's gonna be no vote that night, but I'm not a seated commissioner, and I wanted to offer input
Or ask a question.
or ask a question during the public hearing. Because the obvious problem is if you're an alternate, you don't know.
Yep, yep.
Yeah, but also, you could just stand up, walk away from the table and.
There's a difference, a critical difference between the decision-making, participation in the decision-making session and participation in the public hearing, okay? I think an alternate who is at the meeting, and let's say you have your full membership at the public hearing, and you got the 3 alternates there, although they are not sitting technically, I think that they could participate, ask a question, or make a comment. I don't think there is any prohibition on that.
Well,
I
there
don't-
shouldn't be, because members of the public can do that.
Right.
So certainly alternates should be able to do that.
Exactly. So I don't have any basis to say they cannot. There is case law, though. There is case law that does say that if you are not eligible to vote, you should not participate in the decision. All right? Now, in fairness, the case I had was an appeal was taken, and a member who had said that I missed the public hearing in between, and it came to the decision-making session. That member said, I know I can't vote because I missed the public hearing. But I really think that you ought to approve this application for reason 1, 2, 3, 4, 5. They approved the application. A neighbor, budding owner, appealed the approval. And part of their appeal was based upon the regular member who did not attend the public hearing, who disqualified herself from voting, participated in the hearing. And then the appeal was resolved because my claim in defending the commission was that the vote was 5-0. It was a 5-member, so the ones that voted, it was 5-0. We had affidavit that none of them were influenced by the statement of the person who didn't affect them. But the principle was that person should not have participated. And that's a case that I'm relying on, even though in that case, there's like no harm, no foul, okay? But the principle was, if you aren't voting, you shouldn't be able to convince other members one way or the other.
Well, it's a better judgment of the chairman to poll the members that voted for if somebody is, slips. It can happen. Somebody slips in comments and doesn't get caught, and then say the chairman realizes what's happened, is the better course to poll the commission that votes.
We
So
did
you
that,
weren't influenced
we
by
did
any of
that
his comments.
in another context. And in the context of disqualification of a member, where it's the member who must disqualify himself or herself, okay? And in that context where a member did not disqualify, where the question arose as to whether or not this would affect the decision, and the person participated, I had recommended, I believe the commission did, poll the members as to whether or not they're vote was influenced by the participation of the other members. And again, it was a case of, if they shouldn't have participated, then no harm, no foul. Okay, if the court ultimately found that they shouldn't have participated, at least the decision would have been protected by polling the member. But you don't want to get to that. You know, you don't want to have
No,
to.
I mean, in the event it should happen.
Yeah, exactly. That's what you'd have to do.
The other thing you said that I didn't realize is that if a full member is not eligible to vote on a particular application, that for that application, an alternate can be seated. I didn't realize that was the case. And I've been chair for a while, I never did that.
You know what I need to do, is I need to have that decision so I can digest it,
Okay,
because this is getting complicated.
okay.
Why'd you bring it up, Mark?
Am I oversimplifying it? Am I oversimplifying it when I say that there is no decision to be made until the motion is seconded by a voting member of the board, right?
Now,
But you're still influencing.
You are oversimplifying it. As soon as the public hearing ends, the clock starts for the decision. Usually, it is either on the agenda, under regular business, where it now comes up for discussion. That's the start of the decision-making process, not the motion.
Right, the opening of the meeting with it on the agenda.
And usually, if things are appropriate, say, okay, when it comes up, let's start with the motion and then discuss it, okay? But most of the time, it doesn't happen that way. It's discussion, then, okay, you kind of heard, all the thoughts, does somebody want to make a motion? Okay, it would be oversimplifying it. That's participation. You can't be involved in that discussion before the motion.
The important thing for us to remember then is, if somebody's gonna recuse themselves, they need to do it well in advance so that everybody knows that this guy's not gonna vote, and he's gonna have to step down, we're gonna have to put him.
Well, they're supposed to recuse themselves before discussion begins.
Well, usually they recuse before the public hearing.
Yeah, yeah.
Right.
Yeah.
They should.
And what if they didn't attend the meeting?
I think that's the confusion part, is when they don't attend the meeting. The person that doesn't attend the meeting, that's really gonna be backtracking on our list of.
That's more the circumstance of attendance at meetings than recusal. Recusal
Usually
usually.
different than.
Right.
I mean,
Right.
if you're ineligible to vote, you can't participate in discussion. Period.
Yeah.
So, but what's gonna happen, Anselmo, is that as the application comes before us, before we go, we ask who's eligible to vote. In the past, we just go, whoever's been seated, right? We still have to ask them if they're eligible to vote, but you didn't have an option to put another person in, to say, at that time. Now, we have the capability to doing that, from what I'm hearing.
Possibly we ought to put that in the order of business, that anything that's on the agenda for that evening, we determine who's eligible to participate,
To vote.
to participate or to vote.
But it's only in cases of public hearings.
No, but I'm saying, no, I'm talking about, this is the evening of the regular meeting. And at the beginning of the meeting, we take the roll, you make your comments, but I think as an order of business, which is not in there now, we ought to say, these are the 5 things that we're gonna review tonight. Is everybody eligible? And is there anyone here who's planning to refuse? Is there anyone in here who's not eligible? At that point, an alternate could be seated for that purpose.
You could listen to the tapes from the previous and make yourself eligible for the public hearing.
Right.
For the decision making.
For the decision making, not for the, but what I'm saying is that at the beginning of a meeting where you have a number of applications that are on the agenda, it's not, early in the meeting, I think it would be good to say, are there any people here who are seated who are not eligible? Or are there any people who are planning to recuse themselves on any of these items? At that point, you could seat people for those who are not eligible or those who are not, just for those that they're not, for those
Well,
particular
I think
cases.
it's probably just as effective to do it on an item-by-item basis.
Right, as you go through.
Yes, exactly.
I think
That's what we
that's
do,
what
but
they
we
do.
didn't then enforce it, so
We didn't, we weren't aware.
we weren't aware we could.
Right.
At least, I wasn't.
Yeah, I think I think do it on a case by item basis, but what you need to do is keep track of any items that are being continued as to who was there, so that when you get to the eligibility to vote, close public hearing, you pretty well
The
know
clerk-
who's going to be able
The
to.
clerk
has a very good record.
identifies
Correct,
those who have attended the hearing, or hearings,
right,
and then the question comes, are the other regular members?
right. And I think one of the things that the alternates, I think, even if you have everybody there during the public hearing, should be allowed to participate. And it's logical because they may be required to vote, so they should participate. And I know of no prohibition during the public hearing which would not allow an alternate, even though technically not seated, not to be able to participate at that stage, okay? Once that hearing's closed, boy, it's like the roster for the World Series, you gotta figure out who's eligible, and those are the only guys that get to play the voting game.
Yeah, but we've always allowed alternates to participate.
In the public hearing.
The public hearing,
Yes.
right, that's good,
That's fine.
that's good.
Once, a number of years ago, I understand that planning and zoning had a difference, a legal difference with the zoning board of appeals. Could you bring us up to date on that history? What was that all about, and is it anything we should be mindful of?
I don't, yes, I know there were a case which involved a personal friend of mine. And so I recused myself, and Mark Brantz represented the commission. The commission believed that a variance was improperly given on a beach property. And so they appealed, I believe they appealed the decision of the ZBA granting the variance. It was, maybe to make it easier, if you, it was David and Marcia Kalajian, Dr. Kalajian on the beach, and his wife. And he-
Well, I'm not particularly interested in those particulars. It's more about under what circumstances.
They got a variance to do something on their property.
Right.
They were granted a variance. The P and Z, sitting at that point, believed that that variance had been given improperly.
It goes back to the idea of the regulations being, are not the plan of conservation and development, but the consistency, it still has to be consistent with the regulations. And that, it was a matter of, was it consistent with the regulations?
The comprehensive plan.
The
To grant a
comprehensive
variance, you
plan.
have to have a hardship, and the relief
Hardship.
has to be consistent with the comprehensive plan, not the plan of conservation.
Yeah, right. That's different.
The comprehensive plan, which is the concept of your regulations in their entirety. Okay?
So ZBA
So
grants.
there was an appeal taken by the Planning and Zoning Commission of that decision. I believe, Mark Grants handled it, and I
Did we
think,
get it?
I'm pretty sure we did.
Just
I don't know, I I don't know what happened, because all I know is Marcia came up to me at some point later and said, we finally got it. I said, oh, well, so I don't know what happened, whether they won, lost, settled, or what.
Well, in
I don't
theory,
know.
what we're saying is, if, based upon the comprehensive plan, not the plan of conservation and development, but based upon the comprehensive plan, if P and Z feels that ZBA granted on the basis of a hardship improperly, we could probably appeal every decision we make.
I wouldn't disagree with you.
I
I
mean,
think
hardship is
Hardships.
hardly a
Hardship-
hardship most of the time.
hardship, it's
It's a legal hardship.
Where it comes up, and again, I'm involved in one in another town, is where a variance was granted for an access, because they didn't have enough room for an access, but it was denied as to the house that the applicant proposed. And I think it was proper, because the denial, they had a hardship, but the house was far more than what they needed in order to be granted relief. And so it didn't meet the comprehensive plan, it didn't have both parts of it. So most of the time, I think that you gotta have two. Hardship is, who knows what hardship is? Comprehensive plan.
Well, hardship should never be, I can't make as much money off of this parcel.
Correct. It's not economic unless the regulation so diminishes the value of the property as to be confiscable.
Effective denial of use.
We had one of cases which, actually I handled for the, I handled it for the ZBA because John Bennett had a conflict on it. But it had to do with a property which had been purchased at a tax sale. And that was the issue was it confiscatory not to allow them to build on that property? And because it had been purchased at a tax sale and the price was so low, court found that it wasn't confiscatory. So the denial of a variance to build on that property was upheld.
Well, I have almost 10 o'clock. Is everybody sufficiently satisfied?
This was so much fun, we ought to do it again next month.
Go ahead.
This is probably a whole nother night session, but is there any, how do we find out about questions of ethics, like you talked about how you had a conflict? Should we defer that to another time, or, I mean, I got some specific questions, like if there's a consultant that's representing an applicant, and I've worked with them or for them in the past, do I have to recuse myself because of that relationship? Or is there like a year, like do I have to be more than a year having?
I'm going to give you a real quick, if I can. Statute says you must disqualify yourself if you have a personal or financial interest in the application, okay? And financial is usually pretty clear, okay? Personal gets more murky, but the real standard is that the public is entitled to be able to have confidence that decisions of board members are made without their having being biased in favor or of an applicant. So do that, make that judgment. And a lot of times what you may want to do is simply disclose for the record that if you think it's close enough, disclose it for the record. Just state for the record that I do not believe that constitutes a personal financial interest, I should disqualify myself. And usually either the applicant or the applicant will say, we have no objection to it. That's usually what.
Well, if you can state for the record that you can still be fair and impartial despite your knowledge of that individual. I mean, judges do it all the time. You know, they practice law with some of the judges that are sitting on the bench that would go before. I mean, they would be disqualifying themselves left and right, and they couldn't be fair and impartial. So it's a judgment call, plain and simple. But, you know, if you think it's that close, you might want to mention it, like Attorney Royston just said. And then state for the record, you don't believe it will prevent you from being fair and impartial.
I have, before commissions, that commission members are clients of mine or personal friends of mine, but it is not a matter of disqualification, and it's, they haven't felt constrained to mention it, nor do I. Because it isn't, you're gonna know a whole raft of people. You're gonna know applicants, you're gonna know representatives of applicants, because you know them, because you have dealings with them, does not disqualify you. Okay? And I don't think the general public, if you take a look, somebody gonna, you know, I play golf with the engineer for the applicant. I know him, it's a friend of mine. Do I have to disqualify myself? You know, I don't think any fair-minded person says, geez, no, you have to. I don't think so.
Relative, close personal friend, somebody you grew up with next door, or you're best friends with, or you socialize constantly, those are critical. But
Particularly for an applicant, not so much their, you know, the applicant's engineer, the applicant's attorney, but if the applicant himself was your favorite golfing buddy,
Yep.
I think, I might question your impartiality, you know.
I mean, I think if it's difficult for you to vote no on an application because you think it's going to damage the relationship, you probably want to recuse yourself anyway.
You have to.
I mean,
If that's the case.
right, I mean, you don't want to be put in a position of voting yes when you know it should be no. Right? I mean, that would seem to me the,
Yeah, I think when in doubt, if you feel it's close and if you state it for the record, and if there's, you know, no issues involved, or somebody, even somebody in the commission that said, gee, you know, I think that's too close, take that into consideration. You know, I think, and there's been experiences on this commission where I think people have had the opportunity to make the decision. I'm not going to comment on whether the decision is right or wrong, but I think the opportunity was there to make a decision, and the individual members got to make it. Okay, and like we discussed, what happens if somebody thinks it's improper? You don't have to go through, you know, polling the commission as to whether or not they were influenced by your vote. You know, I think that in any case, it's better to disqualify yourself. Then there's no question.
if it creates the appearance of impropriety, you should disqualify.
The appearance, that's correct.
on the issue of undue influence from either, you know, political or, you know, town leaders or what have you, is that something that one should disclose? What should one do when?
That would only be I think that would come in the qualification of either bias and predetermination, if you felt you could not give a fair decision based upon whatever may be an influence upon you, whether it be political, personal, religious, what have you. I mean, it could be your parish priest or your minister or your rabbi saying, how could you vote that way if you feel, oh man, I can't make a impartial decision because of those influences, then you should disqualify yourself.
Well, the predisposition, if I may interject, if you've advocated very strongly for one particular thing, and then you find yourself having to make a decision on something related to that particular thing, I think most people would say that's a predisposition. And you should probably recuse yourself. That's my sense of it.
That's the one that gets really, really difficult because it's a question of degree. Has your advocacy of a particular position been to the point where you really have to say, you know, regardless of what they come up with, it's all garbage. I'm not going to believe it anyways. Then you can't make a fair decision. I think it's very difficult for a person who's advocated positions not to disqualify himself if the specifics in a matter comes up.
And you mentioned the parish priest. We had the issue a long time ago. St. Mary's coming before us to do an addition. And the neighborhood said, well, everybody who's on the commission from St. Mary's should recuse themselves. St. Mary's would have liked that because we wouldn't have had a quorum, and so it would have automatically been approved with no condition. But we made the personal decision that we were going to be in part. It would have been an easy approval because we wouldn't have met the.
That's right.
Yeah,
Yeah,
it's an automatic approval.
second
We
round.
can vote.
Okay. Mr. Royston, thank you very much. I think you've
Thank
all
you.
been helped a great deal going forward as commission members. I think it's a good idea to do this on a yearly basis, but I also want to encourage commissioners to avail themselves of the many seminars that are out there periodically, and we have a budget item for that purpose. So I encourage all of us, myself included, to try to attend these things, because as you can see, it's not crystal clear an awful lot of times, and the more you know, the better off you're going to be in the service you give the commission and consequently the town. That's it for me. Thank you.
Thank
Good
you.
night.
Make a motion to adjourn?
Second. All in favor?
102?